This is a reviewer for labor law, starting with the preliminary title or Chapter 1 of the Labor Code of the Philippines, Article 1, the name of the decree. This decree shall be known as the Labor Code of the Philippines. Some comments on this. So some salient features of the Labor Code is that it reorients labor laws towards development and employment goals. It also institutionalizes the NLRC to facilitate the speedy settlement of labor disputes. Further, it establishes a new system of workmen's compensation, a system for employment of overseas workers, and it optimizes national benefits therefrom in the form of dollar remittances and improved skills and technology for our people. As well, it institutionalizes voluntary arbitration as a mode of settling labor disputes. Article 2, the date of effectivity, it shall take effect 6 months after its promulgation. So the Labor Code took effect on November 1, 1974, and it was promulgated on May 1, 1974. So Article 3, Declaration of Basic Policy. The state shall afford protection to labor, promote full employment, ensure equal work opportunities regardless of sex, race, or creed, and regulate the relations between workers and employers. The state shall assure the rights of workers to self-organization, collective bargaining, security of tenure, and just and humane conditions of work. So some notes here. So what is the reason for affording protection to labor? Protection to labor is intended to raise the worker to equal footing with the employer, thus shielding him from any abuses that may be brought about because the employer and the employee are not on equal footing, and the employee has the necessity for survival. In the case of Sanchez versus Lyons, Lyons, the employer stands on higher footing than the employee. First, because there is a greater supply than demand of labor. Second, the need for employment by labor comes from vital or even desperate necessity. So, because of these two reasons, the employer is assumed to stand on greater footing than the employee. Article 24 of the Civil Code also provides that in all contractual property or other relations, when one of the parties is at a disadvantage on account of his moral dependence, ignorance, indigence, mental weakness, tender age, or other handicaps, the courts must be vigilant for his protection. The extent of the protection under Article 3, is that the protective mantle granted by this law is available not only against oppressive employers, but also against unscrupulous union leaders. See here the case of Teodulo Cruz versus CIR. Here, the union was found to be an agent of its members for the purpose of securing for them fair and just wages and good working conditions, and is subject to the obligation of giving the members as its principals all information relevant to union and labor matters entrusted to it. In this case here, however, the union leadership was recreant in its duty towards the union members for failing to disclose the full situation of their judgment credit against the respondent. Fair dealings, which is fiduciary in nature, arises from two factors: degree of dependence of the individual employee on the union organization, and corollary to the first is the comprehensive power vested in the union with respect to the individual. So that's the extent of protection given under Cruz versus CIR. What are the limitations of the Declaration of Basic Policy under Article 3? The protection of labor cannot be used as a pretext to defeat the rights and prerogatives of the employer, because the labor code is for the benefit of both the employee and the employer. So thus, if the dismissal of employee is questioned, the validity of this dismissal is questioned because the employee found guilty of violating rules designed for the safety of employees themselves, this dismissal should be upheld because it protects labor and at the same time gives the employer its due. The protection to labor cannot be used as an excuse to distribute charities at the expense of the employer. Courts cannot render judgment on the basis of sympathies and inclinations, and consequently distribute charities at the expense of the employer, because our constitutional government assures the latter against deprivation of property, except in accordance with the statutes and supplementary equitable principles. Protection to labor is not available where both parties have violated the law, because in such a case, neither party is actually entitled to protection. Article 4, construction in favor of labor. All doubts in the implementation and interpretation of the provisions of this code, including its implementing rules and regulations, shall be resolved in favor of labor. So what does this mean? First, there's the reason for Article 4, there's the applicability, and then there's the limitations. The reason for Article 4 is that doubts are resolved in favor of labor because this is in line with the principle that those who have less in life should have more in law. Again, remember the unequal footing. When conflicting interests of labor and capital being the employers, are weighed on the scales of social justice, the heavier influence of the latter must be counterbalanced by the sympathy and compassion the law must accord the underprivileged worker. A contrary ruling would be a dilution and emasculation of the protection to labor clause of the Constitution. So what is the applicability here? Article 4 applies only when there is any doubt as to the implementation and interpretation of the provisions of the labor code. Where the evidence is clear that an employee is not an asset but a liability that delays production or sets a bad example for his coworkers, the courts should not hesitate to confirm or order his dismissal. So, if there's no doubt, there's no room for construction. There's no room for applicability of Article 4. The limitation of Article 4 is that the fundamental principles of due process should be applied both on the poor and the rich to attain proper justice or substantial justice. The benevolent policy of the law towards the employee does not oblige courts to be unjust and unfair to employers. Article 5. Rules and Regulations. The Department of Labor and other government agencies charged with the administration and enforcement of this code or any of its parts shall promulgate the necessary IRRs. Such RRs shall become effective 15 days after the announcement of their adoption in newspapers of general circulation. So a grant of quasi-legislative power to the DOLE or other government agencies charged with the administration and enforcement of the labor code or any part thereof. There's also POEA, the National Wages and Productivity Commission, Employees Compensation Commission, and LRC. The limitation here is that you cannot enlarge or amend provisions of the labor code. The effectivity of the labor code's IRR is February 3, 1975. Article 6. Applicability. All rights and benefits granted to workers under this code shall, except as may otherwise be provided therein, apply alike to all workers, whether agricultural or non-agricultural. The labor code applies only to employees in the private sector, whether agricultural or non-agricultural. If you're looking at other employees, such as government employees, you have to look at different laws. So government employees are covered by the Civil Service Law. GOCCs created by special charter, also Civil Service Law. GOCCs organized under the Corporation Code, look at the Labor Code. To be covered by the Labor Code, thus, you need to have an employer-employee relationship. What are the criteria for an employer-employee relationship? You can look here at the case of Viana versus Alagadan. First, selection and engagement of employee. Second, payment of wages. Third, power of dismissal. Fourth, power to control the employee's conduct. So you have selection, wages, dismissal, control. So for selection, this is the hiring. A written contract may not be necessary. The selection and engagement of the employee is an understanding that one is to render service to the other, and a recognition by them of the right of the other to order and control the other is sufficient. Next, payment of wages. Wages are defined as the remuneration of earnings. Wages are considered paid in consideration. Considered wages if paid in consideration of labor being performed or the results of finished work. So remuneration of earnings. Earnings are wages if it's in consideration for labor being performed or the result of finished work. Next is the power of dismissal. The person hired is subjected to the rules of discipline of the employer. Fourth, power to control the employee's conduct. This is the most important element in the employee-employee relationship criteria test. Here, the control test says that the person for whom the services are performed reserves the right to control not only the end to be achieved, but also the means to be used in reaching such end. The control should be used on both the means and the end. Distinguishing then from, say, insurance agents. These are salaried professionals who keep definite hours and work under the control and supervision of the company. So an employer-employee relationship exists. What about registered representatives who work on a commission basis? There is no employer-employee relationship. The nature of the relationship between a company and its collecting agents depends on the circumstances of each particular relationship. There exists an employer-employee relationship between a corporation and an in-house lawyer if they are paid regular salaries. Employer-employee relationships also exist between a school and its professors. The school has control over the work of the professors, and the latter are compensated for their services by wages or salaries rather than by profits. What about working students in colleges or universities? There is no employer-employee relationship. Such rule applies only to labor controversies and not to civil suits for damages arising from a tortuous act of a working student. Employer-employee relationships also exist between doctors and the training hospital, unless there is a training agreement between them, and the training program is duly accredited and approved by the appropriate government agency. Between hospitals and their consultants, employer-employee relationships exist only for the purpose of allocating responsibility in case of medical negligence case, so medical tort. Employer-employee relationships also exist between the jeepney owner and the driver unless there is a boundary system. So these are just some comments from jurisprudence. Between a shipping company and the workers of stevedoring or Arasta companies, there is no employer-employee relationship unless the same in fact acted as agent only. Between when there's a contract, an employer-employee relationship is created by contract and cannot be forced upon either party simply by order of the labor arbiter. Any competent or relevant evidence may be admitted as proof of the employer-employee relationship, and in the following 5 cases, the employer-employee relationship may be deemed suspended or is deemed suspended. When the employer is under supervision, either as a disciplinary penalty or as a preventive measure during the pendency of disciplinary proceedings against him, during off-season in case of regular seasonal employees, when fishing vessels are dry docked or undergoing repairs, when an employee is laid off for a period not exceeding 6 months due to suspension of business operations, when an employee fulfills a civic or military duty. What about the termination of the employer-employee relationship? This can be through 3 means. First, dismissal. Second, resignation or abandonment of employment. And third, expiration of the employment period. What are factors that do not interrupt the employment relationship? First, leave of absence with pay. Second, illegal dismissal. And third, strike. So that is Article 1 to 6 of the Labor Code. Now going more into the introduction to labor law in general. So labor law, by definition, consists of statutes, regulations, and jurisprudence governing labor capital relations. It regulates such relations by providing employment standards and a legal framework for negotiating, adjusting, and administering such standards and other incidents of employment. What are the classifications of under labor law? First, there are labor standards and labor relations. Labor standards are matters of law setting minimum required terms and conditions for employment. They are to be complied with by the employers, and these are matters of right for the laborers. Labor relations, on the other hand, define the status, rights, and duties governing individual and collective interactions with employers, employees, and their representatives. Laws on labor relations apply when there is a collective bargaining agreement. These regulations governing individual and collective interactions are basically the rules of bargaining. So labor standards, minimum requirements for employment, labor relations, these are for collective bargaining agreements. Next, you also have Social Security legislation. These provide protection and benefits to society in furtherance of social justice. This is different still from general social legislation, of which the Labor Code is an example. Next, the concept of social justice as a justification for labor law. Article 2, Section 10 of the Constitution provides that the state shall promote social justice in all phases of national development. Article 13, Sections 1 to 3 provides that Section 1, Congress shall give the highest priority to the enactment of measures that protect and enhance the right of all the people to human dignity, reduce social, economic, and political inequalities, and remove cultural inequities by equitably diffusing wealth and political power for the common good. To this end, the state shall regulate the acquisition, ownership, use, and disposition of property and its increments. Section 2. The promotion of social justice shall include the commitment to create economic opportunities based on freedom of initiative and self-reliance. Section 3. The state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunities for all. It shall guarantee the rights of all workers to self-organization, collective bargaining and negotiation, and peaceful concerted activities, including the right to strike in accordance with law. They shall be entitled to security of tenure, humane conditions of work, and a living wage. They shall also participate in policy and decision-making processes affecting their rights and benefits as may be provided by law. The state shall promote the principle of shared responsibility between workers and employers and the preferential use of the voluntary modes in settling disputes, including conciliation, and shall enforce their mutual compliance therewith to foster individual peace. The state shall regulate the relations between workers and employers, recognizing the right of labor to its just share in the fruits of production and the right of enterprise to reasonable returns to investments and to expansion and growth. Article 2, Sections 18 and 20 of the Constitution provides, Section 18, the state affirms labor as a primary social-economic force. It shall protect the rights of workers and promote their welfare. Section 20, The state recognizes the indispensable role of the private sector, encourages private enterprise, and provides incentives to needed investments. So thus, there are two tracks for the furtherance of social justice. First is by the diffusion of wealth, by the regulation of acquisition, ownership, use, and disposition of property, and second, by the creation of economic opportunities. So to compare the development of how the constitutions have treated labor, so the 1935 Constitution, social justice as a justification for labor laws. So Article 2, Section 5 of the 1935 Constitution stated that the promotion of social justice to ensure the well-being and economic security of all people shall be the concern of the state. In 1973, Article 2, Section 6 said, the state shall promote social justice to ensure the dignity, welfare, and security of all people. To this end, the state shall regulate the acquisition, ownership, use, enjoyment, and disposition of private property, and equitably diffuse property ownership and profits. Article 2, Section 10 of the 1987 Constitution states that the state shall promote social justice in all phases of national development. The case of Calalang versus Williams gives the definition for the balancing of interest. It states that social justice is neither communism nor despotism, nor atomism nor anarchy, but the humanization of laws and the equalization of social and economic forces by the state, so that justice in its rational and objective secular conception may at least be approximated. Social justice means the promotion of welfare of all the people, the adoption by the government of measures calculated to ensure economic stability of all the component elements of society through the maintenance of proper economic and social equilibrium in the interrelations of the members of the community, constitutionally through the adoption of measures legally justifiable or extra-constitutionally through the exercise of powers underlying the existence of all governments on the time-honored principle of salus populi es suprema lex. Social justice, therefore, must be founded on the recognition of the necessity of interdependence among drivers and diverse units of society, and of the protection that should be equally and evenly extended to all groups as a combined force in our social and economic life, consistent with the fundamental and paramount objective of the state of promoting the health, comfort, and quiet of all persons, and of bringing about the greatest good to the greatest number. So it's utilitarianism. So if you need a definition for social justice, you look at the case of Calalang versus Williams. The case of San Miguel Corporation versus Del Lasario also states the balancing of interest, as the balancing of interests requires the employer to present the best evidence obtainable to prove that the termination of the disadvantaged employee is valid. So that's the balancing of interest test under San Miguel Corporation versus Del Rosario. Next, police power and state protection. This is the foundation. The case of St. Luke's Medical Center Employees Foundation versus St. Luke's Medical Center Employees Foundation versus NLRC. Police power allows the state to regulate the grant of the right to security of tenure to safeguard the welfare of the people. The state can then require licenses, even if it would mean the dismissal of those who are unable to comply with such requirements. So, police power grants the state the right to regulate the right of security of tenure. So that's St. Luke's versus NLRC. What about the limits of use? The case of PLDT versus NLRC. This policy of social justice is not intended to countenance wrongdoing simply because it is committed by the underprivileged. At best, it may mitigate the penalty, but it certainly would not condone the offense. Compassion for the poor is an imperative for every humane society, but only when the recipient is not a rascal claiming an undeserved privilege. Social justice cannot be permitted to be a refuge of scoundrels any more than equity can be an impediment to the punishment of the guilty. Those who invoke social justice may do so only if their hands are clean and their motives blameless, and not simply because they happen to be poor. This great policy of our Constitution is not meant for the protection of those who have proved they are not worthy of it, like the workers who have tainted the cause of labor with the blemishes of their own character. Therefore, one who is dismissed for breach of trust due to the acceptance of a bribe may not be entitled to separation pay. That's PLDT versus NLRC, so the limits of use of social justice as a basis or justification. Next, Toyota Philippines Corp versus NLRC. Toyota Philippines Corp's Workers Association versus NLRC. Separation pay is not to be given to those dismissed for serious misconduct, willful disobedience, and breach of trust. So moving now from social justice to the legal basis or the sources of rights and benefits. So there are several international instruments here. So first is the International Covenant on Civil and Political Rights, particularly Article 22 there. Article 22 of that, just read on that. International Covenant on Economic, Social, and Cultural Rights, Article 6, 7, 8, and 9 of that. International Convention on the Elimination of All Forms of Discrimination Against Women, you have Article 11. And so there are 8 core conventions of the International Labor Organization. The first is the Forced Labor Convention. The second is the Freedom of Association and Protection of the Right to Organize Convention. Third, Right to Organize and Collective Bargaining Convention. Fourth, Equal Remuneration Convention. Fifth, Abolition of Forced Labor Convention. Sixth, Minimum Age Convention. Seventh, Discrimination, Employment and Occupation Convention. And eighth, Worst Forms of Child Labor Convention. So the case of the International School Alliance of Educators versus Kisumbing, it is unacceptable for a school to give foreign hires higher pay and more benefits for the same position and the same job as local hires. So note that according to Philippine jurisprudence, the right to work is actually a property right. Therefore, as per Article 2, Section 1, one cannot be deprived of work without due process of law, because one cannot be deprived of their property without due process of law. So the cardinal labor rights enshrined in the 1987 Constitution are sevenfold. First is the right to self-organization. Second is the right to collective bargaining and negotiation. Third is the right to peaceful concerted activities, including the right to strike. Fourth is the right to security of tenure. Fifth is the right to humane conditions of work. Sixth is the right to a living wage. Seventh is the right to participate in policy and decision-making. Note, however, that all these rights are to be exercised in accordance with law, therefore they may be subject to regulation or police power. So the Labor Code and the omnibus rules implementing the Labor Code are also the bases. You get these are a basis for labor laws. And New Civil Code of the Philippines, particularly Article 19, Article 21, Article 1700, and Article 1701. These state that, under Article 19, every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. Article 21, any person who willfully causes injury or loss to another in a manner that is contrary to morals, good customs, policy, or public policy, shall compensate the latter for the damage. Article 1700, the relationship between capital and labor are not merely contractual. They are so impressed with public interest that labor contracts must yield to the common good. Therefore, such contracts are subjected to special laws on labor unions, collective bargaining, strikes and lockouts, closed shop, wages, working conditions, hours of labor, and similar subjects. Article 1701. Neither capital nor labor shall act oppressively against the other or impair the interest or convenience of the public. So what is a collective bargaining agreement? Article 1305 to 1306 of the New Civil Code provides that, Article 1305 says that a contract is a meeting of the minds between two persons whereby one binds himself with respect to the other to give something or to render some service. Article 1306, the contracting parties may establish such stipulations, clauses, terms, and conditions as they may deem convenient, provided that they are not contrary to laws, morals, good customs, public order, or public policy. The case of Dole, Philippines versus Pawes ng Makabayang Obrero. A collective bargaining agreement is a norm of conduct between the employer and employee, which is mandated by law for such parties to comply. Next, you have past practices. The case of American Wire, a benefit not consistently, notwithstanding its financial status, given by the company over a long period of time, is not a company practice that could be the basis of a right. So the benefit must be given consistently. However, what is a long period of time is not given a definite period under law or jurisprudence. The case of Netlink Computer Incorporated versus Delmo, company policies are the basis of right. When the company habitually gives the same benefit to its employees and has done so for a while, the employee then can demand such benefits. What then are company policies and how can we find out if they exist? The test is reasonableness. The test for company policies is that of reasonableness. Policies could be the basis of right if such are reasonable. The case of China Banking Corporation versus Borromeo says that company policies are binding to both employer and employees so long as such rules and regulations are not contrary to law, good morals, and public policy. Another test to be applied to know whether a company policy should be binding is that of reasonableness. My bad, that is the same test. So that is a general introduction to the labor code based on Articles 1 to 6 of the said code, as well as some notes on labor law and social justice as a classification.